Mr. Trush, were you anticipating Mr. Papp connecting today?
I mean, I would hope so. He is next door at the county jail. And frankly, I mean, I think that he intends to tender a plea to the original offer the prosecutor made today, if that's still on the table.
It's not.
Okay. All right, hold on. Let me, Leanne, can you call over to the jail? I didn't realize Mr. Papp was here. I thought he was still in Department of Corrections. Um, Mr. Trush, rather than, I'd like to put you and Mr. Rolla into a breakout room so that you can talk about the plea off the record and not in front of the court, okay?
Uh, Understood.
Mr. Rolla, are you there?
Yes, Judge.
Okay. I don't know if your camera's off. I can't see
Oh,
you,
I'm
but
sorry.
that's okay. I just want to
It's
make
not.
sure that
There we go. Now okay, I'm back again.
gotcha. Okay.
Actually,
So
I
I'm just
logged
gonna
in
put,
about 22, Judge. Thank you.
okay. I'm gonna put you and Mr. Trush into a breakout room while we're waiting to get Mr. Papp connected.
Very good. Thank you.
Judge, are you still there? Nope. Judge, they're gonna get him on Zoom.
Okay, thank you. Mr. Papp, are you able to hear me okay? You guys able to hear me at the jail there?
Yes, sir.
Okay. The lawyers are talking in a breakout room, so it'll just be a second.
Yes, sir. Mr. Trush, you want? Oh, sorry.
Okay, Mr. Trush, did you need to talk to Mr. Papp?
No. So, Your Honor, having talked to the prosecutor, I think we're going to ask the court to do a couple things today. So one, we are going to ask the court to make a ruling on the motion. And frankly, I think it's more for the purposes of directing us how to proceed in future, because for both of us, I mean, this has some pretty significant implications in terms of how we conduct business in the future. Mr. Rolla indicated that he wanted to talk to the victim. So at this junction, we're gonna I would say I anticipate that we'll have a plea at the hearing next week. I think we're set for Wednesday of next week. I anticipate we'll have a plea then, but he wants to discuss it with the victim. Additionally, there was a new interview done with the victim. I've seen the officer's his report of what it is, but not the video. So I do think I probably need to lay eyes on that as well.
Okay. Mr. Roll, is that accurate?
It is, Judge, and I'd also add additionally, Mr. Trush's office very recently received additional reports, specifically regarding to another witness, Miss Britta Daniels, and the video interview on that. I know he's gone over the report synopsis. I don't know if he's gone through the entire video yet. He hadn't when I spoke to him last Friday. So there's two of those. And in any case, I would indicate we did make an offer. There was some request to change that offer. We've had those discussions. Defense counsel knows what it is, and it would be the people's position that this matter be scheduled for a plea next Wednesday. I anticipate that's going to take place. But again, I do want to speak to the victim in light of the severe nature of the matters before I do that.
Okay. All right. So in terms of the motion, it's defendant's motion to disqualify the prosecutor and to suppress certain communications. I had a chance to review your motion, Mr. Trush, along with the cases that you attached to that. Mr. Roll, I did get your response. I had a chance to review that. I guess one of the questions I had and needed clarifying by either of you is just an offer of proof, because there weren't any of the actual communications attached. There wasn't a lot of factual background about when and how those communications were made and the content of those. So Mr. Trush, or Mr. Rolla, I'm just looking for an offer of proof as to, kind of a little bit more of the details of these messages Mr. Trush, did you want to address that at your motion first, I
So,
guess?
so I can, and Your Honor, I was kind of in new territory here in terms of my worry was if I provide the content of the messages or if I provide them to the court, my worry is now I'm creating an additional layer of taint that I have to address. What I would indicate in terms of the content of the messages, Mr. Papp and I, there, by my count, were 40 or so JPay emails that were between Mr. Papp and myself that were ultimately recovered. Those emails discussed a variety of things in the case, from really starting with how we're going to approach the preliminary exam, to different evidentiary issues, different potential motions we might file. So, from my perspective, I mean, we discussed essential elements of the case that certainly would touch on defense strategy. At a fundamental level, though, I mean, content set aside, which I understand why the court is concerned with that. I mean, the primary concern that I have is, the prosecutor basically having any of my communications with the client to me is concerning. Some of the emails probably don't touch to, strategy, but some of them certainly do.
Okay, all right, that answers that question. Mr. Rolla, then I have a question for you. I mean, is this something that your office regularly does, is get JPay messages and review them? How did you happen to do that in this case if it's not a normal practice? This just seems like I just need more information from your side about how you got these messages and why.
Very good, Judge, and perhaps a little foundation. I can't comment on the content of any of the emails, JPay messages, however you want to call them. Any of the ones that may have had Mr. Trush's office his name on it, or communications. As soon as we saw that those were in there, I put in a firewall scenario similar to what was done in Amerson. And I immediately notified law enforcement that don't open them, don't view them, don't read them. I don't want to know about them. So I have no idea what content they may or may not contain, nor does anybody else in my office. To more directly answer the court's question, this was a very unique scenario. As the court is well aware, and as I put in my brief under the holding in Campo, or Pearson dealt with communications to third parties. Campo dealt with where there's a lack of confidentiality. What had happened and the way these came to the people's attention, and I apologize if it wasn't clear in my brief, but to put it simply as an offer of proof, you had a situation where some emails were sent to the victim in this case, that the victim's boyfriend saw them on her phone. The victim's boyfriend brought those to the attention of Child Protective Services worker, Miss Bobra Johnson, the supervisor, apparently during just a regular home visit, home check. I don't know exactly. I obviously wasn't there. And those messages then were, because of the content of those messages, and to be clear, these are not attorney-client messages. These were messages sent to and received from the defendant and the victim in this particular matter, in the people's opinion, violation of the order of pretrial release. But in any case, because of the content of those, they were then brought to law enforcement's attention. That's how those copies were made. After those were made, then it was found that there were additional JPay messages that apparently had been going back and forth since February of this year through October of this year, and pursuant to the JPay user requirements, which indicate that upon request, they're sent to any law enforcement agency. A request was made about JPay messages. The Department of Corrections, as I understand it, then sent them to the Michigan State Police. But again, there's a big division between communications sent to third parties, specifically involving those going to and from Britta Daniels and to and from the victim with the defendant. Those are the ones that people would be intending to use were the matter to go to trial. If that answers the court's question.
Okay, I think so. Just so your office didn't request those records, and that was something that came to the attention of law enforcement from a third party, and then when you started looking into those messages, or the police, you saw that some of them involved communications between Mr. Trush and Mr. Papp, and those were
Allegedly,
not
Judge, I know they were sent. I don't know what the content was.
right. But you didn't go in there trying to get those, and you didn't view those or record those in any way.
Correct, Your Honor. In fact, we took steps to specifically not have that happen, to avoid even an appearance of interfering with the attorney-client relationship. We just put a block on them and said, no, don't look at them. We don't want them. And in fact, the investigating officer in this case and I had quite the discussion, because it was, well, we don't care what those messages say. We're not interested in those anyway. We're only interested in the ones that went between the defendant and the victim, or the defendant and the victim's mother.
Okay. All right. Thank you. So that clarifies the kind of the background and factual questions I had. Then Mr. Trush, with regard to legal argument, was there anything that you wanted to add in addition to what's in your brief?
Just very briefly. So, there were a handful of cases that were cited by myself and the prosecutor, and I think actually we cited some of the same cases because it kind of outlines the test. I think there's a distinction between some of the cases that the prosecutor cited and the case sort of as we have it presented here. And I think the most similar case to what we have here, while it's not a perfect match, is Jolly. And in that case, I think it's different because in one of the cases the prosecutor cited, I mean, the real issue that the court took up was whether or not the communication is protected because it was essentially planning a crime, right? And obviously that's not a protected communication, right? I mean, that can't be a protected communication. In Emerson, we have a similar situation where the communication I don't think is protected because it's not direct attorney-client communication. What we have is communications from the attorney to an expert who's then later consulted by the prosecution, independent. And I think it's slightly different because the expert ultimately wasn't hired by defense, and it seems pretty clear, at least, that the defense expert, I don't think, gave there wasn't any disclosure of information other than he disclosed, hey, defense consulted with me and they stopped. The case here, though, I think is more close to Jolly, where you're looking at actual communications between the attorney and the client, not sort of tangential communication, but direct communication. And the analogy is pretty strong because in Jolly, it's an email, right? It's an email between the attorney and the client where the client talks about where some things essentially have gone, what he did with them. Based on that, then they get a search warrant and go and get those things. So I think it's more analogous to that. So again, and I guess what I would say here, I mean, I certainly don't dispute what the prosecutor is saying in terms of the steps that he took to try to prevent, any of the information from getting out. But what it doesn't change is the fact that there's a PDF that was produced to the state police. Again, at least on information and belief, went to the prosecutor's office and then was sent to me in discovery, which has, again, a PDF version, a printout of, 40 or so of my emails to my client. Granted, I agree with the prosecutor that the format it's in, if you don't zoom in, you can't read what they are. But I mean, it doesn't change the fact that exists out there now.
Okay. All right. Thank you. Mr. Rolla?
Yeah, thank you, Judge. I agree. Jolly sets out the factors that you have to look at. However, in Jolly, the court only dealt with the suppression situation. They did not deal with a disqualification situation, which is specifically why I cited Emerson. Going back to Jolly, however, though, the biggest distinction between that and this case is in Jolly, once the police became aware that they had attorney-client information, the original email, they took that original email and then they used it to gain additional investigative information in the arson case to find the gas can, the lawnmower, some other matters as well. So they doubled down on screwing up. In other words, they twice did what they shouldn't have done. as opposed to the circumstance in our case and in Emerson, where once it looked like this could be a problem, specific steps were taken to avoid any intentional intrusion much into the attorney-client relationship, much less any substantial prejudice to the defendant. In Emerson, as Mr. Trush indicated, you had the circumstance that, well, once the prosecution found out that this other person who they were going to had listed as a witness and were going to call for trial, had in fact been previously interviewed by the defense, they said, nope, we're taking you off the witness list. We're not going to do that. Went and got another witness, expert witness. In our particular case, once an email indicated that it had defense counsel or his office name on it as being a sending or receiving party, even without looking at the content, steps were immediately made not to look into that further. So where the warning signs came up that were not followed in Jolly, but were followed in Emerson, so was done in this particular case. It's a situation where we're not looking at it. We don't think it's appropriate to be looked at. It may or may not even be relevant. I don't even know. We don't know what the content is, but in any case, people were willing to stipulate that we're not using that, as I indicated in our brief. So it's a situation where actually Jolly, which, like I said, only dealt with suppression, as was noted in Emerson, Jolly did not deal with at all a disqualification of the prosecutor's office because there was no intentional intrusion into the attorney-client relationship, much less any substantial prejudice caused by that. Therefore, there's no due process violation. Therefore, there's no disqualification.
Okay, thank you. Mr. Trush, it's your motion. Anything you wanted to say in response?
So a few things. I mean, I think the real value of Emerson to us here is it's not that it's perfectly analogous, because it's not, but I think what that brings to the table or directs us is that the same process, the same test outlined in Jolly is what you would apply if disqualification is sought. I think that's the value of that case in terms of how it applies to this scenario. And I guess the other thing that I would just indicate to the court is, I mean, obviously this is a difficult scenario, and from a public policy standpoint, right? I mean, I need to be able to have communications with a client who is incarcerated. I mean, that just has to happen. If it doesn't, how do we process cases? I mean, we can't move things forward. If I can't rely on JPays, if I can't rely on video visits and phone calls, because again, many of those things I can't confirm when I call in that they're not being recorded. And sometimes I know they're only semi-private. If I can't rely on those, I mean, effectively, I'm going to be limited to having to travel to to a correctional facility before every hearing. And I don't say this because, oh, I don't want to, do the work, but I say it because every time you put a barrier between that communication, you have the effect of chilling it, right? You have the effect of making it harder. When we make it harder, one of a few things happens, right? And I mean, one, either the communication doesn't occur, which isn't good, doesn't serve interests, or what we do is we make the communication significantly more expensive. And at least in this case, I mean, that means to the taxpayers, right? I mean, if I have to drive to Newberry every time I have to talk to Mr. Papp, the court's effectively going to pay me essentially for a day of trial every time I talk to him. It's not a good use of the taxpayer dollars. And that's partially why, there's three different pieces of relief that I have asked the court to consider. One obviously is suppression of the evidence. The second is, to instruct that those types of communications go through a taint team. And in the context of the prosecutor's office in Otsego, it could be as simple as, his APA reviews it before it goes to him, right? Because conflicts aren't imputed up in a prosecutor's office, they're imputed down. Meaning, because the APA, Mr. Rolla doesn't inherit all of his conflicts the way that the APA inherits all of Mr. Rolla's. Again, I think there's some compelling public policy reasons why clarity here is important. Thank you.
All right, so I did have a chance, of course, as I said, to review the cases, review the briefs cited by the parties. Yeah, I totally see what you're saying, Mr. Trush, in terms of your need to have confidential communications with your clients, with Mr. Papp while they're incarcerated. And I think it does, to some degree, raise a public policy issue, because I don't think it's entirely clear that under the case law regarding attorney-client privilege, which requires communications to be confidential before the privilege even attaches, before we even get to Jolie and Amerson and all those others, we first have to find that the privilege applies. In those cases, that wasn't the question. And I think it is a question here in terms of JPay and whether that should or could be considered confidential to the extent that things that are said are subject to attorney-client privilege and then subject to the tests, which I agree with counsel. I think both of you that Jolie is the controlling case in terms of the test that needs to apply to privilege communications. And I agree, Mr. Church, with your argument as to Amerson, and that analysis would also apply to disqualification, because I think it would be, I think if a defendant satisfies the tests in Jolie for suppression, and those kind of communications have been reviewed by a prosecutor, I think necessarily a prosecutor probably should be disqualified, because they're then privy to specific defense strategies and so forth that they could take advantage of at trial. I'm not sure that the court or any court really needs to make a decision as to whether or not JPay communications are privileged, or whether email communications are privileged, or phone calls or video visits between an attorney and a defendant in a correctional facility. Because I think the Jolly test really provides the protection, as opposed to JPay being, a court ruling that JPay is or isn't privileged, or video visits are or aren't privileged. I think the protections in the three-pronged test in Jolie would adequately weed out any communications that would be privileged pursuant to JPay. And if they weren't privileged, I think that test, even if you apply that test to non-privileged communications or assume that they weren't privileged, it would provide an adequate protection. So I can't say, and I'm not going to make as part of my ruling whether or not the JPay communications between Mr. Trush and Mr. Papp in this case were privileged or were not, because I don't find that the Jolly test has been met by the defendant. So I don't think the court even needs to rule on that issue. I think I can assume for purposes of the motion that they were privileged. As I said, I do think it's an open question though. JPay, from the materials submitted by the prosecutor, clearly, states that those are not confidential communications. I did just some of my own research online with JPay to make myself familiar with that as a communication device, more than I have been just in the general processing of my cases. But it does, if it's not privileged, I understand the problem. But again, I don't know that it's a problem that needs a solution in light of Jolie. So assuming that the communications were privileged between Mr. Papp and Mr. Trush, number one, the court finds that the second prong of the Jolly test is not met, which is a deliberate intrusion. And I think this case is much different than the Jolly case from a factual standpoint, for the reasons stated by the prosecutor. In Jolly, the police believed that there was evidence on a computer. They got a search warrant to go into that computer. They found emails between the defendant in that case and his attorney, and then they used the information in those emails to obtain evidence. And that's much different than this case where at most this was something that was discovered in the process of looking at evidence that clearly was not protected by the attorney-client privilege and statements to third parties by Mr. Papp. Further differentiating this case from Jolly is the prosecutor hasn't attempted to, number one, the prosecutor didn't go into JPay or subpoena JPay or try to discover those messages into JPay for the purpose of looking at attorney-client communications. The prosecutor, once he saw that there were some of those communications in there, he directed law enforcement not to open them. The prosecutor did not look at them. So there isn't anything before the court, even in terms of an offer of proof, that the prosecutor viewed those communications. Certainly there isn't anything to indicate that the prosecutor is going to, wants to, or would intend to use those communications. Part of the reason why I asked this question of the prosecutor, I mean, do you look at these in the course of all of your cases? And it's clear that this is an outlier in terms of prosecutor even having any access to JPay messages, because again, it's not something that the prosecutor, deliberately attempted to get as part of discovery to learn about some aspect of the case. It was something that came to the prosecutor surreptitiously through the course of what was part of the investigation that clearly did not involve privileged communications. So there wasn't a deliberate intrusion. And then the third prong, that there would be some type of prejudice. Again, because the prosecutor didn't review the messages between the defendant and the attorney, doesn't know what the content of those was, expressly directed that those not be divulged by law enforcement to the extent that they had them. The court finds that there wouldn't be any prejudice. So the court will deny the motion on that basis for failure to meet the second two prongs of the Jolie test. And again, from a public policy standpoint, because this isn't something that the prosecutor sought out to get, I don't know that, this is a problem that needs a solution at this time. But either way, regardless of whether they were privileged or not, assuming they were privileged, there was not an inappropriate viewing of those messages to the extent that the Jolie test is violated. So the court will deny the motion. Mr. Trush, I would request that you prepare an order reflecting the ruling of the court today.
Yes, Your Honor, I'll get that prepared and sent over. With the court's permission, though, can I submit that Monday?
Yes. Yep.
Judge, if it'll make it Your Honor, if it'll make it any easier, I already have an order consistent. I did 3 different orders in anticipation of today's motion hearing. I've already got them prepared. I can send the one that I think accommodates what the court just ruled on to Mr. Truce, and then have it forwarded to you for your signature. He won't even have to prepare one unless the court would like to proceed in the original manner indicated.
No, that's fine. However you guys want to submit it, as long as we have an order, just to the
This way you can have it today, Judge.
Okay. All right. Okay. Thank you. That's all for today then. And then we'll be back on the record in this file next week.
Okay.
Very good, thank you.
I'll be over to talk to you, Carl, on Monday.
All right,
All right,
I'll
thank
be
you.
emailing you the proposed order in a moment. Thank you.